There is a serious attack happening on the free press in Washington state. And the only way, I do mean this, the only way to do anything about it is to be okay with going to jail, is to be okay with being arrested, and to spend time in jail as members of the media. This segment is brought to you by Eastside Weight Loss Clinic. Some patients like me can lose 20 to 30 pounds in a month or two. Schedule your free 15-minute consultation today at eastsideweightlossclinic.com. Members of an institution that I do not have a lot of faith in right now will have to be willing to stick up for themselves, to stand together, and be okay with the prospect of being held in contempt of court by a judge and being sent to jail. I'm okay with it. I think that this issue we're going to discuss warrants it. I think it's worth it. And if we do not see a substantial change from the judiciary in Washington state, particularly in King County, then I know that I will. I don't know if any of my colleagues in the media will be willing to do it, but I am willing to stand in front of a judge and force that judge to arrest me, to have me arrested and sent to jail for the crime of wanting to make sure the public knows what's happening inside those courtrooms. Let me explain. So this has been an issue for me. I have two real pet peeves as a member of the media that came to be pet peeves really when I was covering crime and justice. This goes back to the very beginning of my career in Seattle 15 or so years ago. I was in a courtroom or in a jail or a prison or all three in one day. I mean, almost every day. Covering first appearances, covering bail hearings, covering trials. That's what I did day in and day out. At the time, it was incredibly rare as a member of the media to have a judge limit your access to a court of law and to the proceedings in a court of law. You would have that happen occasionally where they'd say, the media isn't allowed to film, or the media is not allowed to record, or the media is not allowed to show the face of a suspect. It would happen rarely. It might happen if somebody had just been arrested and maybe there was a legitimate case to be made that it could be mistaken identity. The person hadn't been charged yet, it was a bail hearing, and the judge could be reasonably convinced that, hey, they're not even sure if this is their guy or their girl. And so we're not going to blast their face all over TV until they're charged. But it would happen very, very rarely. Well, over the years, it has become more frequent for judges to take liberties in preventing the media from having open access to a court of law. It has become one of my significant pet peeves, and I think now it's risen to the level where I think it's an attack on the free press. The other pet peeve I have in this realm, which you all know, is when people we pay with our money, taxpayer money, to be spokespeople for public agencies thwart us, don't respond to our requests for comment, don't put out information to the public, so we're paying them to basically keep secrets from us. So these have become two real pet peeves that I think have become incredibly serious that every member of the media should be concerned about and every member of the public should be concerned about, because when we're limited, when we're blocked, when we're ignored by quote unquote public servants, it prevents us from being able to get information to the public. In the cases of these judges who have taken it upon themselves to protect criminals by limiting the access of a free press in the courtroom, it also puts the public in jeopardy, because when you have people who have been accused of violent crimes and a judge tells us, for no real reason, you're not allowed to film their face and to put it on the evening news. Well, when that person inevitably bails out and they're out roaming the streets, it hurts the public's ability to protect themselves from that person. So you have issues here related to a free press, a constitutional right. You have issues here related to the public's right to know what's happening in courtrooms, in cases that very much impact public safety. And I would also note that there are rules for Washington's court system that govern all of this and have for years. There are rules that specifically lay out the access the media is to have to a court of law. And these are rules that today are being flagrantly violated by judges. And thus is the problem, because what do you do when a judge is flagrantly violating rules and thwarting a free press? So there have been a couple high-profile examples of this. I'm going to get to a third that just happened, but I want to remind you of some times that we have ranted about this very issue on the show. There was a case, you'll recall, this is back in October, where a murder suspect, 19-year-old Jimerson, had been released by an activist judge on $50,000 bail after stabbing a handyman to death. This is from Katie Davis Court, who had blasted this judge out at the time. And this was just about the low bail, something we have become very accustomed to. You had on video, and admitted to it when arrested, Jimerson took a big old butcher knife. First, he attacked a handyman from behind with a pipe, then took a butcher knife and stabbed him to death. Prosecutors, he shows up in court, prosecutors want $2 million bail. Judge Gelson in King County, Michelle Gelson, released him at $50,000 bail so he could go roam and reoffend and stab more people with butcher knives. Now, that was bad enough, and that was the initial part of the story. It's like, what are we doing? He killed someone with a butcher knife, and you're giving him $50,000 bail. That's insane. But then, as our friend David Rose over at Fox 13 later pointed out, this Jimerson had to be rearrested for some new violations. Goes back in front of yet another activist judge. And that judge grants a motion that the media cannot show his face on TV.
This is video from the crime scene showing 20-year-old Jimerson hitting 65-year-old Michael Gray from behind with a broom handle. The video shows Gray then following him back into the apartment. And that's when detectives say Jimerson pulled out a butcher knife and stabbed Gray in the back, killing him. According to court documents, Jimerson called 911 after the crime and confessed. Judge Michelle Gelson, who you saw there, set his bail at $50,000. And 27 hours after he was taken into custody, he was released without electronic home monitoring. The Renton police chief demanded answers, asking why Judge Gelson granted such a low bail. During Jimerson's court appearance in front of Superior Court Judge Johanna Bender, Jimerson's mom wanted to address the court, asking that the media not show his face in fear of what she called vigilante justice. That's when Judge Bender expressed empathy for Jimerson's family.
Yeah, Judge Bender expressed empathy for the family of the killer, who was worried, oh, if you put his face on TV, there's going to be retribution. And that judge granted it. For no legitimate reason whatsoever. You have someone who's on video committing the killing, who confessed to police to committing the killing, murdering an older gentleman with a butcher knife. And you have judges who, just because someone asks them, in this case, the mother of the suspect, says you cannot show his face. You cannot be in the courtroom, and you have to film him from the neck down, which is not in the interest of an open courtroom, a free press, or in the interest of the public, who deserves to know what the guy who stabbed someone with a butcher knife looks like. One of the other real egregious examples, and to me, this one was most baffling. I said at the time, I'd never experienced anything like it in 15 years doing this job. You may recall the case of Wendy Traynor. Wendy Traynor was murdered in cold blood, shot in the back of the head, execution style, by her estranged boyfriend, Josh Ellis, who'd traveled across the country to shoot her and kill her and just leave her dead on the floor of her new apartment. Well, Josh Ellis's case had been going through the court system, and we were covering it pretty extensively because prosecutors had offered Josh Ellis a sweetheart plea deal. You probably are starting to remember this case now. So we went down for a court appearance where Josh Ellis was going to change his plea to guilty because he got this sweetheart deal. So we're sitting in the courtroom as he's getting ready to enter a plea of guilty. Yes, I committed this crime. Yes, I murdered my ex-girlfriend. And his public defender asked the judge that we not be allowed to film his face at a court hearing where he's about to plead guilty to killing Wendy Traynor. And the judge just decided, yeah, that's reasonable. He's about to plead guilty to murder, but no, don't show his face. His picture had been out there on the news already for years. There was no reason to limit the media's access in that moment. And this is going to get a little wonky, but this is so important. And again, I think the only course of action here is to show up in court and be willing to go to jail. So there is something you learn as a young reporter, at least we used to, when you cover crime and justice, where you have an opportunity. If there is a motion on the floor from a defense attorney usually to say, we don't want the media to be able to videotape our client's face, okay? You know, it wasn't unusual for defense teams to ask that. Of course, they're just going to throw it out there like, oh, we don't want our client doesn't want his face on TV. Of course not. No criminal wants their face on TV. But judges would just say, you know, there's a presumption of open access and you have no real good justification for that, so they deny it. Now, occasionally, when a motion happened like that, a judge would grant a media representative in the courtroom an opportunity to make their case as to why they should have unfettered access to the courtroom. And we were taught to use General Rule 16. So as I said, there are rules that govern Washington courts and how things need to be handled in a courtroom, access, and all of those things. I'm going to read for you General Rule 16. Again, this is the judges, the courts are supposed to be bound by this. These are the rules everyone plays by. Courtroom photography and recording by the news media. Video and audio recording and still photography by the news media is allowed in the courtroom during and between sessions, provided that permission shall have first been expressly granted by the judge, and that media personnel not by their appearance or conduct distract participants in the proceedings or otherwise adversely affect the dignity and fairness of the proceedings. And that's okay. Like, yeah, you can film, you can take photographs, you can do audio and video recordings, just don't be in there acting a fool and disrupting things. So it was never an issue. You would always let the judge know and the bailiff know, hey, we're going to be in the courtroom today, and it would never, ever be a problem. And then it says the judge shall exercise reasonable discretion in prescribing conditions and limitations with which media personnel shall comply. If the judge finds that sufficient reasons exist to warrant limitations on courtroom photography or recording, the judge shall make particularized findings on the record at the time of announcing the limitations. This may be done either orally or in a written order in determining what, if any, limitations should be imposed. The judge shall be guided by the following principles. Open access is presumed. Limitations on access must be supported by reasons found by the judge to be sufficiently compelling to outweigh that presumption. Any reasons found sufficient to support limitations on courtroom photography or recording shall relate to the specific circumstances of the case before the court rather than reflecting merely generalized views. Prior to imposing any limitations on courtroom photography or recording, the judge shall, upon request, hear from any party and from any other person or entity deemed appropriate by the judge. So that the key there, open access is presumed. Washington state courts are open to the public. That access is presumed because the public, through the media typically, has a right to know what's happening in court proceedings. So open access through the court's own rules is presumed unless a judge places limitations that are sufficiently compelling to outweigh that presumption and that are specific to the case at hand, not some general feeling that I don't want cameras in the courtroom today. Neither of those two cases that I just explained to you are even close when they made those decisions. No, you can't show the face of a murder suspect who confessed. No, you can't show the face of a guy who's about to enter a plea of guilty to killing his ex-girlfriend. In neither of those cases was there anything even remotely resembling sufficient reasons for a judge to deny open access to a court. And we have another one to add to that. This is stunning to me. And this is the thing that puts me over the edge to say, if something doesn't change, it's time for the media to go into these court hearings prepared to be arrested. Prepared to say, we will not abide by that order. We are going to show his face. We're going to photograph him. We're going to videotape him. Remember the guy who was just arrested before we left for the break for murdering in cold blood a King County Metro bus driver, who, by the way, had another murder case from 6 years ago. His name is Richard Sislak. Well, he was in court yesterday, and King County Superior Court Judge Dave Keenan ruled, you guessed it, that the media could not show his face. Someone whose face had been all over the news. There was a manhunt for him. Everyone already knows what he looks like. There is no reason, no compelling reason that exists to, quote, warrant limitations on courtroom photography or recording. There is no compelling reason that would outweigh the presumption of open access for a free press constitutionally protected. You have a murder case where a two-time murder suspect whose face has already been blasted all over the news. You used the media to find him. You used the reach and the power of the media to get his face out there, to get the video out there of the surveillance video, to find him and bring him into custody. But now that you've done that, you say you can't show his face anymore. Can't videotape him in court. Never mind, he's a murder suspect. Can't videotape him. Can't show his face. No reason in the world that justifies it. It is a flagrant violation of Washington Court's General Rule 16. But it doesn't surprise me, coming from the judges that we've highlighted here and the judges we've highlighted in the past on the show. These are activists in robes, truly. You know, we've talked about some of them at length. This is the first I've heard of this particular judge, Dave Keenan. But one look at his social media, and it doesn't surprise me that he would run cover for a murderer. I mean, I saw a picture of him on social media with a pink gavel. Very demure, very mindful, he says. He's in pictures with Sal Mungia, the Democrats' choice for the newest state Supreme Court justice. You know, talking about Jay Inslee, Democrats, you know, pride events and all of these things, which is fine. But this is clearly someone, based on just a quick perusal of his social media, that is very ideologically driven. So of course he's going to run cover for a criminal, even a suspected murderer. Of course he's going to choose the side of a criminal, like these other judges have, over the rights of a free press and the rights of the public to be informed. Oh, and we also noticed that this particular judge posted a picture with the most notorious activist judge in the entire state, Judge Veronica Galvin. Judge Galvin and I presented for 2 hours on sentencing reform. Eventually, we'll do the podcast we keep talking about. Can't wait for that one. Judge Veronica Galvin, if we can just do a quick, revisit of all the things that she's done. I mean, she's already out there doing podcasts. So if she does a podcast with him, that's fine. But Judge Veronica Galvin, the epitome of an activist judge, here she is on a progressive podcast talking about her philosophy around juveniles and crime and how really we're all to blame.
None of the systems, none of us have clean hands within this context. Because these children are accessing these weapons from adults. They're not going into stores and buying them. From adults who may not be responsible and have them locked up or have them safely to the side. I mean, we see grown people, get upset that somebody cut them off in a vehicle and start shooting. Grown people. And yet we have a higher standard and expectation for a 12-year-old. It's like putting a 2-year-old behind the wheel of a car and expecting that they're not going to hit anything. We have to take responsibility somewhat that we have created an environment in which these weapons are glorified. They are considered something of a thing to have, to be cool or whatever. But this is on us as well. These children did not come into this world, with a machine gun in their hand.
Yeah, this isn't on us. That's the mindset, though. You have this judge notorious for letting violent offenders off the hook just because they're young black and brown men. Sending them home, no bail, maybe electronic home monitoring, notorious. You can do the worst of the worst crimes, end up in front of Judge Veronica Galvin. And as long as the shade of your skin is right and your age is correct, then you get to go home, slap on the wrist. And she wants to have these podcasts saying, oh, we all bear some responsibility. Does that mean you? I'm not taking responsibility for what these juveniles are doing. It's not my fault, but it sure as hell is your fault for not showing them that there are consequences on the back end of that, and they just can't go home with a little ankle monitor that they'll end up cutting off and running away. Just a few of this case came up recently, and I just have to revisit it since we're talking about these activist judges and the mindset that would have them have a murderer in front of them and tell a free press, you can't show their face on TV. You probably heard about this while we were gone. Gang-affiliated teen kidnaps 14-year-old, ties him to a tree, disembowels him 2 weeks after Judge Veronica Galvin released him from custody. Yeah, a horrifying case. You've got a teen. Judge Veronica Galvin had sent him home. I'll get to more on that in a minute, the case. He goes out less than 2 weeks later, ties a 14-year-old up to a tree and carves him out. This is from Cairo 7. Court documents, teen stabbed at Everett Park by rival gang over a girl. There's 2 teens who were suspected in this. The teens pistol whipped the boy before pinning him to the ground and stabbing him multiple times, carved an N on his chest for Norteños. The Tulalip teen reportedly told the boys, "This is what you get for acting tough." The boy told detectives that the pair made him strip, then used his clothing to tie him to a tree and left him to die. He reportedly waited for them to leave and then untied himself and ran to the nearest home for help. Yeah, one of the teens that did that carved up a 14-year-old and tied him to a tree. 17-year-old Malores Canales. He shouldn't even have been on the streets. But it was because of Judge Veronica Galvin. He had been charged with first-degree assault, first-degree kidnapping, and robbery in this one. But before that, this is from Post Millennial, court records show that Canales was released from custody by King County Juvenile Court Judge Veronica Galvin on December 2nd, only 2 weeks before the Everett attack. He had been held on juvenile detention on felony charges for a robbery in Seattle that occurred on November 15th. Prosecutors asked for him to be held in custody awaiting trial, but Judge Galvin denied the state's request and released Canales to home monitoring. So here he was in juvie detention for a robbery in Seattle just on November 15th. And then Judge Galvin says, go on home for the holidays. On December 2nd, less than 2 weeks later, he's carving out a 14-year-old kid and hanging him by a tree to die. That's their mindset about the criminal justice system. Let's see, what else did she do? Yeah, the kids who brought modified guns to the Chinatown International District Seafair Parade. Can you imagine if some white person, some white adult, was caught with, they were modified to be like fully auto, weren't they? Yeah. Was caught with it at a parade. They'd be calling it an act of terrorism. But some little gang members do it. And Judge Galvin releases them to electronic home monitoring. She also had released a 12-year-old who was accused of using a ghost gun in a Seattle carjacking. Yeah, 12 years old, going to use a ghost gun in a carjacking. Go on home. It's no big deal. God, I could go on and on. There's so many of these. The attacker who fractured the skull of a singer at El Corazon. Yep. Sprung from jail by none other than Judge Veronica Galvin. And that's the judge who's friends with Judge David Keenan, who just said the media can't show the face of the guy who murdered a King County Metro bus driver in cold blood. They're all ideologically captured. They all run in the same circles. They all are looking out for the interests of criminals ahead of the interests of the free press and the public. And they can get away with it because the free press as it is right now is almost non-existent, and nobody fights back and nobody pushes back. Oh, and just to bring things full circle, can I just note, you know how there was 2 teens who were involved in the attack on the 14-year-old where they carved him up and hung him from a tree to die? And one of them, he should have been in jail, but he wasn't because Veronica Galvin sprung him loose. Well, then they both got arrested for the attack on the 14-year-old. Well, yeah, another judge got involved. The other teen, Hayden Lucenbrink, 17, who was involved in it. Oh, he's out now. He's out now, thanks to Judge John Scott of Snohomish County Superior Court. Gang-affiliated teen accused of kidnapping, stabbing, and disemboweling a 14-year-old boy in Washington State has been released on bail. Judge Scott set his bail at $300,000. The defendant posted bond and was released from custody on December 20th, jail records show, to carve up and hang another 14-year-old boy from a tree. The only way you get special treatment in Washington State is if you are a violent criminal. I believe it. There is no reason in the world why the media, why the public should be prohibited from seeing court proceedings, especially involving violent criminals who are often committing crimes at random against innocent bystanders. Why are the courts protecting them? Why are the courts trying to protect their identity? And all of this to say, and again, I go back to, it's in violation of their own court rules. Judges have some discretion, but the discretion has to be specific, it has to be just, and it has to outweigh the fact that there is a presumption of open access in the courts. And until the media comes together even with the likes of us, and pushes back collectively, nothing's going to change. And it might take a few members of the media who are willing to go to jail at the order of a judge for refusing to comply with these bogus rulings. So if Judge David Keenan wants to hold us in contempt at the next court hearing, if we show up and we want to show the face of the guy who murdered a King County Metro bus driver, and Judge Keenan says, you can't do that, you can't videotape him, then I'm going to say, well, we're going to. We don't believe you have compelling reason under Rule 16, and we're not going to abide by that ruling. And he can hold us in contempt of court, and he can put me in a jail cell. And we'll see if any other members of the media are willing to stand up for themselves and thus stand up for the public. It really is a troubling trend that shows that the judiciary is completely out of control.